The GDPR takes effect in May 2018. There are still plenty of people, I think, who feel that Brexit is going to save us from having to worry about the GDPR. Forget it, Brexit will take place at least a year after the GDPR takes effect. And whether or not it does, even if that was not the case, we need to be on top of the GDPR and all those data protection implications if we want to keep our place in the flow of data across the Atlantic and elsewhere. The Information Commissioner's Office has been working, I have to say, really rather well on this. It's a very good resource if you want to keep up with what's going on. The government has expressed its intention to abide by it, but firstly, the government doesn't, on the whole, seem to know a great deal about this subject, as we know from the Snoopers Charter. And secondly, it's not going to have an awful lot of time. So I think that it's going to be down to us, to some extent, to get this right, to get the whole management of data compliance and the transatlantic data flows sorted out. Because why do we call this Europe's wall, you might wonder? Well, I think we've called it, somebody said it was to do with Trump. I think we've called it Europe's wall because if we don't get it right, data flows and all the work that goes with it will hop over the wall to Dublin and be dealt with there, and we'd rather that it stayed in London. In case there's anybody here who hasn't caught up with the main provisions, what do we have in the GDPR? Well, there's an enhanced definition of private information, which is going to be relevant to our case study. There's a wider geographical scope. Is the data of an EU citizen is what matters. There are new duties for data controllers and data processors, new and enhanced rights for individuals and corresponding duties for companies. Data privacy officers are going to have to be appointed in companies, and we're going to have to notify in the case of data breaches. That's only a fraction of the things covered by the GDPR, but those are the sorts of things that are going to be touched on by the case study that we're going to go through. That's a hypothetical, and I must pause to say thank you very much to Sue for drafting the hypothetical. For those who haven't had a chance to read it, it's about a company called Believer. Believer makes a dating app with a focus on religious beliefs. So we've got religion and we've got dating in there already, so a lot of private information going to be gathered there, obviously private information. Sexual preferences are going to appear as well as religious beliefs, as well as the everyday sort of private information, names and addresses and perhaps credit card information and so on, are all going to be part of this app. So that's going to matter. Sue has introduced some other complications into this story. There's threats of US IP litigation. There's an ex-employee who's threatening both contract and tort claims in relation to the development of the application. The Financial Conduct Authority has written to express interest in information that was given out at the time of the IPO. And there are rumours that user data may have been compromised or leaked. So all in all, this company is facing a lot of difficulty, potential difficulty anyway. We've transported you to June 2018 for these purposes, which gives us the opportunity of saying, I wish I'd done that. And that's really what we need to try and encourage people to do. There's a mixture here then of what should have been done by the implementation of the GDPR, what should be done in the various circumstances that we've just described, and generally, what should we be worried about? What would we be less worried about if we'd solved the problems, addressed the problems earlier on? I'm going to start with Will. The app itself, let's look at. What sort of practical and technical problems should have been addressed before the implementation of the GDPR?
Well, thank you very much, Chris. So, hands up, I'm not an app developer. I'd like to get this clear. I'm not writing this app because there's a whole load of hurt that could be in it. However, GDPR, as Chris has just outlined, has some very specific requirements about managing and owning customer, client, potential client, and basically anybody's data. So if I was writing an app or advising a client who happened to have an app, it would be, so what sort of data are you planning to collect? Where are you going to store it? What do you intend to do with it? How are you going to keep that separate from the business transaction side of things, which may be of interest for floating the business, but protecting the information assets about your clients, your customers, personal information which, being in July 2018, now everybody knows there's maybe one or two high-profile cases, or this might be the high-profile case that's going to reinforce how good practice for everybody else. So the first thing I would be doing when I visit Cumbria, they're based out of, is to have a very good long chat with whoever's been appointed by the Data Protection Officer, or with the head of IT, who is basically going to default as the Data Protection Officer, to start talking about, are you aware of your obligations? Do you have some good lawyers on board? Because you've got some issues here if you can't even identify how you record your data and where it's stored, how it's accessed, how the developers are interacting with it. So aside from any litigation, just good data management practice is going to be absolutely key to this particular client. And of course for anybody else that's involved in any kind of data that involves people.
And you're making an assumption there that a data protection officer will have been appointed.
And if he hasn't, then of course we're already in breach of our regulations if we have actually got any customers.
Somebody I interviewed the other day made the very good point, somebody who's in this industry made the very good point that who are we to go and talk about what other companies ought to do if we as companies have not got our own compliance sorted out in advance of the implementation of the GDPR. Sue, let's take it a bit wider from the app. How should the company have best prepared for the sort of circumstances that we've just described?
Well, thank you, Chris. I think anytime there's the possibility of litigation, whether there's a specific possibility of litigation or specific contemplated litigations, as there is in this hypothetical case, I think I can't emphasize enough from the disclosure side of things, obviously the importance of planning and also of tracking everything that's being done. Obviously these same considerations come into play very much with data protection issues, GDPR issues as well. And I think it's really important not just to panic, for lack of a better word, and focus on the immediate potential consequences of being involved in litigation, but really thinking about the long game and the bigger picture and trying to think about what can be done as quickly as possible, sort of in contemplation of what's coming 3 steps ahead. So to answer your question about what should have been done, obviously having various litigation preparedness plans in place would have been ideal, but also I think the company very much should be, as it is required to do under, will be required to do under the GDPR, track where and how information is being kept, what the different types of information are. And Dan will talk more to the specifics of the obligations, but really I think planning ahead and also tracking what's being done is very important. And then thirdly, equally important for anticipated disclosure as for data protection issues is really thinking pragmatically about the realities. And so with any luck, the company already has some policies in place that are useful and helpful, but at the same time, everybody needs to be taking into account what real people are really doing at the company. So it's one thing saying, for instance, that everybody should be storing their communications that involve personal data in this certain way or in this certain place, but the company, the data protection officer, which we hope exists, needs really to be tracking whether or not real people are complying with that, and if not, where and how they're storing this information so that the company can comply as well as it can, but also it can be prepared for litigation and understanding where exactly information may be found.
So appointing a DPO on the day before the GDPR comes into force is not particularly helpful.
I think that's safe to say that, yes.
And from what you say, there's a higher level of preparedness needed than for the one would normally expect for anticipated litigation, particularly where there's a US context. There's a pretty high burden anyway, but you're saying there are higher burdens placed on companies now, or will be after May 2018.
I think there will be for a couple of reasons. I mean, first of all, obviously that potentially might involve taking data outside of the European Union, which is troublesome from a data protection perspective, but also because the US litigation in particular tends to involve discovery, which is broader in scope than disclosure would be in England and Wales, and that can be a real issue as well, because people might not be realizing the scope of what might be sought, and also you don't know what the particular court in the United States might consider reasonable in terms of compliance with the discovery requests. So I think one would hope that things are improving more and more, and there's more international awareness of particular data protection obligations, but it's better not to get to the point of having to fight that battle with a lot of legal arguments in the States.
What was implicit in something you said earlier was that there's effectively a compliance obligation quite apart from a litigation obligation.
Yes.
To know more about your data than people may feel necessary at the moment.
I think that's right, and I think Dan will probably talk to that with much more detail than I will.
Dan, let's move on to you. Firstly, to finish off that question, what should people be ready to face in terms of litigation holds, litigation readiness, general sort of keeping a track of where their data is?
Yeah, I mean, one thing to be aware of is the GDPR essentially uplifts the current rules we're operating under. So whether it's in a litigation context or any other context, you should expect when the GDPR comes into effect that the rules we're living with today will be much more robust, and that will have a particular resonance in the litigation context. So if you're confronted with this kind of scenario, I think the first thing I would do is in your head, and this is to your compliance point, go through each, almost in a matrix style, each of the various GDPR requirements and understand which of those are going to be implicated by litigation, right? So here you have a situation with an international dimension. So the first thing you have to ask yourself is, well, probably be cross-border transfers of data. We have rules today which impose restraints, but this, and that doesn't change under the GDPR. We're in June 2018, so we know those will still be in effect. So your first thought, or one of your thoughts should be, how do we deal with that? GDPR also uplifts the requirements for things like notice. So you have to think to yourself, well, whoever is, the data that is being sent or processed in connection with this litigation, are the relevant individuals to whom the data related sufficiently aware? And if not, do we have an obligation to inform them? To the point Sue was making, proportionality. I mean, that's an extremely important principle today. It'll be even more important under the GDPR. And it has special importance in a litigation context because of the wide-reaching scope of some of these litigation or discovery requests. So you have to ask yourself, well, how do we tailor our responsiveness to these document production requirements so that they're proportionate as a matter of EU law? And those are just some of the obligations you need to think about. So that's substantively. Just a quick point on process. If you have appointed a DPO, what's expected under the GDPR is a lot more sort of internal investment in compliance. So you would naturally expect your DPO to be involved fairly early on in terms of decision making and how you respond to this. In addition, there's things, data protection impact assessments. So what you would probably be expected to do is perform this impact assessment before you comply, before you run through all the procedures to make sure your compliance is there and you've not overreached in terms of responding to document production requests. So, I mean, that's only sort of a flavor for some of the things you need to be thinking about in June 2018.
There's a long story been running for a while of data protection regulators taking against US demands for discovery, particularly if the US court is, if you like, scornful of the EU position. Can we see? Can we expect to see a change in that, or are there beyond additional duties? Are we going to see a change in attitude on the part of the regulator?
Yeah, and this historically, if you're not aware, there's always been an enormous tension between European data protection rules and how regulators view the application of those rules and U.S. litigation requirements. And beginning with the paper in 2008, when the EU regulators basically posited that compliance with U.S. discovery procedures almost inevitably creates this conflict with European rules, there hasn't really been a great resolution to this tension. And efforts have been underway. Probably the best known example is through a conference called the Sedona Conference, which has a working group to try to resolve this conflict. But it's not been resolved, and I certainly wouldn't expect under the GDPR for European regulators to back off and say, you know, compliance in these processing data in connection with U.S. litigation, you know, it's open season. If anything, there'll probably be even more intent to enforce these rules, given all the recent disclosures in the US with respect to PRISM. I mean, there's a very skeptical attitude amongst European regulators about what happens to data once it gets to the US. If anything, I think the situation will probably be worse.
Which is a much wider subject that touches on the Microsoft Dublin case, all sorts of different aspects of it. But just looking at our little Cumbria company, should they be reading the Sedona International Principles, for example?
I think they should. If you look at the principles, they make a lot of sense. They're very, if you haven't seen them, I think they're 6, and they talk about basically undertaking efforts to engage in a reasonable and proportionate document production exercise, putting in place or seeking court orders in the US to protect the data, or creating stipulations that both parties agree to manage document production. And when you read the advice, it all seems quite logical. And I mean, I would think if you follow that, at least you have a good faith argument. You've attempted to, walk the narrow line between compliance with EU rules and compliance with US discovery requirements.
I think there's an important point arises from that. Since nobody knows how these rules are going to play out, what the detail is going to be, and how the various moving parts are going to interface with each other, those who can say, we did our best, we tried, we took advice, we did this, we did that, we did the other, are likely to persuade the regulator or whoever is peering at them, at the least, to go off and trouble somebody else, because there's going to be so many companies that are non-compliant. The ones who can say, we did our best, are likely at the very least to be able to push the regulator off somewhere else. Is that a fair way of putting it?
I think that's a very good point, absolutely.
Sue, let's come back to you, and expanding and giving a bit more flesh on this. What should a company do when litigation is actually threatened? We have a room full of people here who earn their livings out of dealing with data when litigation is threatened. But does the GDPR add anything to that?
I think, well, it adds a number of things, and obviously this all ties into the preparedness point, I think, and also very much the need really to understand the company's data, and then in connection with the litigations or the contemplated litigations, really understand what elements of the company's data are impacted by the potential litigations. So I think there are joint efforts are involved here in understanding, first of all, the people, places, and things from which information that may be required either to defend the case or to for disclosure or discovery purposes can be identified as quickly as possible, and then to carry out a second analysis of what the company's data protection obligations are with respect to each of those. And I think there's quite a big matrix, obviously, on the disclosure side of things. I think it's really important to understand very quickly everything that could be implicated, whether or not there will be a request touching on it, or indeed whether it might be useful for the company to investigate this particular device or type of data in order to make an affirmative point. And so it's important to move very quickly to do that, and at the same time really to understand, ideally of course to have already had lots of analyses in place and tracking systems in place and policies in place, so that very quickly the one analysis can be done from a litigation disclosure perspective, and at the same time and immediately the data protection analysis can be carried out, and any further specific steps that need to be taken can be put in place as well.
What we mean specifically there is identifying the personally identifiable information of anybody who's likely to be referred to in any of the potentially relevant documents.
I think that's right, and the only way to be able to do that is first of all to figure out what the potentially relevant documents, what the potentially relevant universe might be. And in the case of Believer Co, obviously there are all sorts, as you discussed at the beginning, there are all sorts of potentially very sensitive personal data that could be implicated here. So it's important, first and foremost, as quickly as possible, really to understand what the scope of these potential disputes is, and to understand a bit what kind of data might come into play, and then really to understand what the specific obligations are with respect to those.
This is not just in a US context. There was an interesting story of a couple of years ago when the Treasury solicitor, of all people, handed over data for UK disclosure, so it's purely domestic, no foreign element involved at all, handed over a load of documents to comply with their disclosure obligations, the government's disclosure obligations, of course, without even applying their minds to the question whether there was any personally identifiable information in there of people who that they ought to have paid attention to. And the Information Commissioner's Office got rather cross with them and put them under, they didn't punish them, they didn't fine them, but they put them under some sort of reporting obligation for a year to make sure they did it properly. I suspect there's quite a lot of people here who have handed over data. I certainly did in my day in litigating without really thinking about it, handing over data without applying your minds to the question whether you ought to be looking after, giving more care to, the data of people affected by this legislation. Will, as a practical matter, do you come across this?
Absolutely. And putting myself in July 2018, it's only going to be even worse. Right now, particularly with smaller tech companies, a compliance culture is not in place because people who develop apps, we have these really cool ideas, we want to be mashing bits of data together to get something new out of it without necessarily thinking about the obligations that has. But practical implications of we have data, we store it, oh, we use Google Hangouts, we have Google Drive for work, actually we use Office 365 as our local email system. So where is the data going to be sourced from? How is it going to be sourced? Can it be sourced in a forensically defensible manner? Is it defensible at all? Can I go and access it? Is it happen to be, where is it being hosted? Where are we going to find it from? And then working back from that to then try and work out what might be in it. I can feel frightfully old-fashioned by saying who keeps the data protection asset register of their personal data. It's been a content, it's been a thing that the ICO have been on about for years. I've come across one company that actually maintained one and actually logged it in their risk register and said, we keep personal data, that could be a risk. And this is going back years, so with the explosion of the ability to be able to host data wherever it's cheap, quick, easy to store, easy to access, available on multiple mobile devices for simultaneous collaborative working, it's creating an absolute minefield for identifying the stuff that we shouldn't just be giving over.
And who's starting on this? So that when the problems arise, you say you're meeting it all the time. Is it the lawyers who say, oh God, we've got to deal with this? Is it the company? Is it you when you get hauled in? Who first thinks of it as a problem?
Bigger organisations that have seen other people get beaten up by it. Banks are a very good example. There's usually somebody at any point in time being beaten up for doing something badly.
Beaten up by whom?
Usually regulators.
Okay.
And if not, then it's the press or somebody else for doing something. So they have a very good focused mind. There is a compliance function in place. But again, particularly in sort of technology sectors, it's so far behind. It tends to be either working with experienced data protection practitioners who've been there before, or a client ring us up and say, we might have a bit of an issue, can you come and help? And we'll tell them, say, so what's your issue? Okay, let's step back. So where is your data? How do you store it? How do you process it? What do you do just day in, day out for your business? Now let's start picking out the potential risks involved in cross-border transfers. Where do you store it? And so it becomes consultative with the lawyers who may be coming in to then help.
Another significant point there. Those of us who have a litigation background tend to think of this as a problem that arises in the context of disclosure in litigation, or perhaps when a regulator comes along, a regulator, not a data protection regulator, but a regulator in the industry. Actually, these restraints, these restrictions, these duties lie on the data that we transfer every day, the ordinary course of business. Dan, is this a real threat, or is this just something that pundits talk about? The threat that of a data protection regulator wading in to punish you for what you have or haven't done?
Well, definitely, I think it is a risk. If you're asking about is it a risk in a litigation context, I think it's fair to say I've seen more activity amongst the continental DPAs and the ICO. But the big consideration and the big sort of game changer under the GDPR is the heightened level of sanctions and fines. So if you get that assessment wrong and say, well, the regulators won't intervene because they'll never hear about it, the consequences would be really quite severe. The GDPR now ratchets up the level of sanctions to, I think, 2 to 4% of a company's global turnover, so that's quite significant. And the idea is to bring it in line with some of the anti-competition fines that we're seeing in Europe. So whereas I think in today's world, companies may be content to say, we're going to take the risk that we might infringe data protection rules to comply with their discovery obligations, and what's the big deal? If you get that wrong in 2018, it is a big deal. So, and also there's a special, as I said before, when transfers of data go out of the EU to a country that's not adequate like the US, I mean, there's just a lot of attention given to that. You can just read the press and the media reports. So if they were to become aware of it, I think you would see most regulators stepping in and at least certainly investigating. And if they feel that rights have been infringed, probably bringing levying fines. And of course, the fines would be quite high. So I think it definitely is a risk.
Are they staffing up, do we know? Are there more people being employed to do the investigations?
Actually, that's a really good point. A lot of them are complaining that they have all these additional responsibilities, but yet they're not given funding to comply or to put these responsibilities into effect. So, and of course, it depends on the country as well. Enforcement would still be performed at the member state level. So you'd have to look at the country you're talking about in particular. As far as the ICO is concerned, I'm not aware they're staffing up, but someone may have more up-to-date information on that. But I mean, certainly, they're going to be focusing on this pretty closely. There's no question in my mind about that.
It's not going to be difficult to identify companies who have foreign transactions as a matter of course.
No, yeah, that's true. And a lot of the enforcement to date has been with companies which have a global presence and they anticipate will be engaged in cross-border transfers, maybe deal with a lot of personal information. If you're highly litigious, and this is in the press quite a bit, I expect they'll maybe pay particular attention to what your practices are.
If one was to be thinking about it more positively, as opposed to merely defensively and negatively, which is the natural reaction. Actually, I'm not being critical of those whose reaction is a defensive, negative one. I interviewed somebody last year who, and I said, is it the fines? What is it? And this is an American lawyer. Is it the fines? What is it? And he said, my clients just want to keep doing business. Is that a fair way of putting it? Any of you?
Yes.
Yeah. It's a perhaps part of a broader information governance picture, is it? Sue, what do you think about that?
I think
Are we going to see people using the GDPR as the motive for getting on top of their data in a better way than they have?
I guess one hopes so, and I think certainly information governance is something that is gradually becoming more familiar to more companies of various sizes just because of the stories in the news and even just sort of laptops left on train type stories, which are a few years old now. But I think this is traveling beyond the sort of large multinationals that have compliance departments to your smaller startup type companies like these developers. And I guess we'll have to see how much GDPR press there is sort of outside of the legal and technical industries. But I think there is a growing awareness generally that these are issues. I think the first step probably has now been taken that more people are aware to sort of flag issues, even if they don't know what the answer is and need to go to somebody to give the specific legal advice that you'd expect. But certainly, yes, certainly I think there is a little bit more public awareness through the media and through some sort of quite public cases. But I think there's still a general misunderstanding, I think actually sometimes even with lawyers as much as with people at companies, of how this actually affects them as real people. I think just as you see a lot of lawyers who sort of think, well, obviously everybody, the client must keep everything in exactly the correct form of storage and always do this with personally identifiable information and everything. I think sometimes it's always very important to remember that real people do things in real life in ways in which they possibly shouldn't. And so I think there's still some disconnect between what people think they're doing and what people think other people are doing, and that should always be borne in mind.
It's often quite salutary when you speak to discovery lawyers, people get involved in disclosure as a matter of their everyday business, and you say, do you know how data is kept in your firm? And on the whole, they don't. It's not something they need to know, and yet there's an expectation that your client will know.
I think so, and I think people think that everybody else files all of their emails where they're supposed to file all of their emails and files all of their documents where they should be. And I think sometimes that's an unrealistic expectation of people. And I think it's important to take that practical view anytime you're dealing with disclosure or discovery or information governance, that have to try to understand what actual people are actually doing.
They're using apps like Believer's app. They're collecting data, they're storing data, they're not realizing none of us realizes how much data, at least I don't realize how much data I'm collecting all the time. How do I offer it up for discovery? Will, are you finding proactive interest on the part of clients? You've given the impression thus far that you're called in with your fire hose to damp down the problems. Is there also a growing interest from potential clients in solving problems before they arise?
Yes.
With a GDPR element?
Going back to answering the previous question as well, on the proactive side of things, it's been very heartening to start seeing far more requests of, we were aware the GDPR is coming in, can you help us assess our readiness? Can you help us make sure that we're either certified, whatever that means, but we want some sort of audit to say that we're going to be compliant. And it's a more proactive take on, you have to have a data protection officer, whereas it used to sit primarily, it would be the head of risk or compliance, who is now responsible for IT risk and compliance. We're starting to see more communication between heads of functions within certainly medium to larger organisations, where the people affected by GDPR recognise it's no longer just, oh, well, that's head of compliance's problem. It's not. It's the head of IT, because the head of compliance may be very well versed on FCA regulations, but probably
they're going to have to talk to each other.
Yes, they're actually talking to each other. And so certainly some of the meetings that I've been asked to go to and have attended have now involved multiple stakeholders from within organisations. And this is a really positive step. I mean, there's a lot more organisations out there than I'll ever have time to go and visit. But GDPR is being used both probably from a public awareness point of view of, we are actually using this deadline to motivate people to start talking, so that when it goes wrong, we won't get beaten up for it, because we can demonstrate that we've had a third party come in and look at what we're doing. We've taken those steps you were referring to earlier to try and mitigate the risk involved in our organisation.
The complaint that we hear from companies for years now has been, I can't see the return on my investment in information governance. Are we now finding an ROI in IG? Sorry about all these initials, but you know what I mean.
It's multi-million pound fines or 4% of global turnover. That certainly in medium to large firms, that's enough to make somebody go, is that a risk to us? Yes, it is.
Dan, are you seeing the same?
Yeah, I mean, the impression I get is that there's initially sort of apprehension, and it's increasing to a degree of panic. And that really sort of, from what I was seeing, changed this year as companies realized, I guess we're nearly, 16 months away from GDPR. A lot more clients asking for secondments and people who can basically get them to comply. And like you were saying, some of the expectations are unrealistic. And part of the problem is a lot of the GDPR principles they're not fully fleshed out. We're still expecting some guidance. So you're kind of hitting a moving target. But I definitely get the impression for the big multinationals who are worried about their reputational damage, let alone fines, they're very much onto this. They're at different stages.
My own feeling is that people are at least as bothered about reputation as they are about the fines.
Yeah, that's true. A lot of people asking for benchmarking to see how their peers are doing. For the small startups, I'm not so sure. I see what you're saying, so I think for a lot of them, they're still in that break it and we'll fix it later mold. Maybe they'll change their mind as they get closer to 2018. But certainly, my sense is that companies it's not, as I said, it's moving from apprehension to kind of real panic and, desperate for resources. And I guess hiring guys, companies like you to help them get compliant. Because they want to get to 2018 and have something that says we've done what we needed to do.
Anybody out there got a different story? In other words, coming across complete lack of interest, knowledge, understanding, clients who simply haven't heard of it? No one's willing to admit to that. Is there a...
Depends on the sector you're looking at.
Right?
Depends on the sector and the size of the company. So I speak to some small companies, they don't understand it, they don't care, they do nothing. Some of them even waiting for enforcement and say, well, clearly bigger companies, speak to their EDM.
Is there a general sense around the room that the clients are aware, are interested? Some nods, anyway.
And the difference between being aware and
Indeed. I didn't necessarily mean interested in the sort of passionate sense. I meant interested in the sense of at least being willing to appoint somebody to start looking into it for them.
I think there's also a distinction between being aware and doing anything about it.
Yes. But being aware is a prerequisite for doing anything about it.
It doesn't mean that action
No.
follows.
Certainly in the US, the feedback seems to be that people are getting their policies sorted out, at least in principle, but still not doing much about the data. Is that your experience? Will's the only one probably who actually
Yeah.
gets involved in the data.
I can pass.
I've spent a lot of time reading through people's policies and procedures, and generally the policies and procedures are getting better. They're getting more watertight. They're getting more prescriptive about how staff should be doing things. What's missing is the enforcement of that. How do you check? How do you validate? How do you audit compliance with the things you said people do? Having a great policy in place is no defence at all if you don't prove that you can make people follow it. It's a difference looking at certain regulators who say, well, one person who failed to follow it is an isolated incident. Systemic failing of nobody follows it, that's where we start adding some zeros to the fine. That's something that senior management need to be taking on board as an issue. So getting the policies and procedures put together is a start, but actually there's more effort involved in making people follow them.
Sue, let's put a bit more flesh on this conflict between EU data protection restraints and US demands. And the US is effectively standing for anybody who, in this context, for anybody who demands data that you are constrained from handing over. What should they be doing in sort of rather more detail than we've done already to get to resolve that conflict, to comply with US, in this case, requirements, whilst being compliant?
They, as in the team handling litigation,
Yes.
you mean? Well, in order to resolve the conflicts, I mean, obviously the most important thing to do is to be proactive as early as possible to make sure that expectations are managed with the other side and with the court in the United States to ensure that any issues, any potential issues in terms of what sort of information may be provided in discovery or anything else are flagged as early as possible so that you don't get to a point where there's contempt of court or where there are various motions being made in the United States court because there was an expectation that thing A would be done and actually thing B would be done. Obviously managing that, ideally there will have been information governance work done well before any of this happened so that the company is in a very good position to understand, as I said, understand its data and understand its obligations.
You're expressing a hope here rather than a,
yes,
a
exactly.
common fact.
So in real life, I think again, this is partially a planning issue, but also an expectation management issue. Again, also proactively working here in the UK, here at the company, in order to figure out as a practical matter what can and should be done, where the really dangerous points are in terms of information that's particularly sensitive or that's particularly important from a regulatory perspective. And then from a very practical perspective, thinking about how to satisfy the needs of the court, the needs of the litigation in a way that is respectful of the information involved and compliant with data protection regulations, but that it also, as a practical matter, enables the company to provide the type of information and the amount of information that is being sought. And so again, the more that can be done early on to understand what kind of information there is, what kind of facts are going to come at issue in the litigation, and then to manage everybody's expectations on both sides of the pond, so to speak, I think the easier and better it is for everybody. I think the worst thing that can happen is not to address these issues early on with the US court, and then to get to a point where everybody's very angry and then try to do something about it.
And does the German court raise different problems? So remember, there was an IP claim from Oregon and a contract claim from a former programmer based in Germany. Does that raise different issues?
I think it raises a few different issues. In Germany, there are various German legal provisions, not just about data protection, but about employee rights and everything else that affect the collection of data. which in some instances make it even trickier actually collect data from individuals, depending on where that person works. If it's at a company, there may be a works council in Germany that has a very strong opinion about whether any data should be collected from the company and what's done with it if that's done. And so again, actually collecting data from Germany or trying to compel the claimant in this case to provide information may actually be trickier than it would be in England, and certainly trickier than it would be to get from a party that is American in the United States. Again, as a practical matter, one solution or one thing that should be done is really to think about other sources of the same types of information. So if the company knows that this claimant holds thing A, B, and C, but they also suspect, and I think in the hypothetical, there are all sorts of different types of electronic communications, different sources of data, really to think about and understand all of the different sources of these types of information and then address that by, again, as a practical matter, figuring out what is needed to defend the particular claims and think about what is the practical solution that could be proposed to the court when planning, really at the CMC stage, when planning what's going to be done with respect to disclosure.
Dan, does this come up as a real issue, or is it just something that we pontificate about?
Oh, no, it definitely comes up as a real issue. There's been a number of cases and litigations in the U.S. where litigants have had to raise this either on the basis that they can't produce or be responsive to document production requests and ask the court to accept that as a justification, or instances where they've had to discuss it with European data protection regulators and ask them whether it's appropriate for them to share information. So I definitely have seen it in a number of cases. So it is a problem.
And are historically, have the German data protection regulators been helpful when approached like this? There's a lot of fear. People say, I'm not going to go anywhere near that regulator because once he knows I'm doing this, then I'm going to be supervised too closely.
Yeah, I mean,
what's the advice to people on
interestingly, I mean, some litigants look upon involving say a German regulator as a positive, because then it provides them with a bulwark against production. You know, if you have a memorandum or a letter from a German DPA saying you can't produce and you don't want to produce, well, that's very helpful to have.
You can go to the American court and say, I'm not making this up.
Right.
Here is a real
Yeah, exactly. It's better than a letter from legal counsel. So you know, obviously there's a lot of strategy involved. I think authorities will be less inclined to permit production than others, and a lot of times that's bound up in sort of cultural perceptions and the like.
And it's not going to get easier after May 2018.
No. Part of the problem is, I mean, European regulators don't accept foreign litigations as a legal basis for providing data out or transferring data out of the EU. They look at that as a separate interest. So that's the tension you run into if you're a litigant. You can't rely on the fact that you're being sued outside the EU and say, look, can we send data for this purpose? They won't accept that. So I think, this is going to be a problem certainly in 2018.
What about post-Brexit in the context of the other litigation here, the German litigation against the UK? After Brexit, is that going to be harder? Or do we not yet know?
I don't know what to feel that one. I mean, go ahead, please.
No, I mean, I think it's too early to tell because there's so many variables still, but I don't think it will be easier. I think that's probably safe to say. Whether it's the same amount of easy or not remains to be seen.
Is that something that firms of your sort of standing are being asked to advise on? What should we be doing differently now just in case there's a different climate after Brexit? Is that something that clients are as yet aware to, or is there just so much else to worry about?
I think there are a lot of clients who are robustly planning for what might happen in Brexit, not just in this context, but certainly in this context, as well as all of the other legal pieces that may need to be addressed very quickly. And I think there is a lot of planning and a lot of advising going on so that firms can identify the key areas of concern to them and really move forward in planning for that.
And Will, in your experience, is the threat of European litigation as big a driver, or is it all US stuff? Are you coming across people engaged in or worried about litigation going one way or the other with the other EU countries?
I haven't come across that so much directly in terms of cases. It's most of the ones I've worked on have been from within the EU going to the US, so being US-driven litigation. That said, I have spent time, having come over from the UK, going around Germany helping a client collect data involved in German litigation with a German regulator, wanting to get somebody in who just went around the site. The data didn't leave the site, it was processed on site, and only relevant material was pulled out. It was checked by a lawyer who was travelling with me to make sure that it wasn't going to breach anything, so it never left the client site until it had already been checked, vetted and approved to be submitted by the end of that week to be first past the post. There isn't, I don't think, an awareness outside of the EU that kind of thing happens, though I like to mention I was speaking on a panel year before last in America talking about these sorts of issues and said you have to have a mind to how you're going to approach collecting this data for your initial review, because if you get it wrong, for example, in Germany, you go to prison. And my co-panelist put the hand up and said, well, actually, that was us. We had 2 of our own people arrested just before Christmas a couple of years ago for not getting that right. And, my work there was largely done, but it underlines it underlines the practical implication of how do you structure your data? In this particular scenario, it's a contract dispute. Well, it's probably common sense to most of us here who've been around a while, but you keep your contracts in a separate part of the file shares for contracts that you don't put PII in. Makes common sense, but certainly smaller organisations that have a somewhat more ad hoc process to filing those documents tend to just dump it in a store and say, I'll sort it later. All of a sudden, they are now potentially disclosable sources. You're into the whole sort of muddy model of, well, what else could be in there that we can't just quickly go through.
Can I pick up on that point?
Yes,
because
do.
one of the things I've seen, and I'd be curious about your reactions, is continental authorities tend to be a lot less familiar with common law systems of discovery and really shocked at how expansive it is. And so to your point about maybe tension following Brexit, I mean, I could see that sort of developing because the attitude they have is it's just overreaching and far too excessive. And I think that's influencing their attitudes towards discovery practices, predicated on common law systems, litigation systems. I don't know if that was your experience, but that's something I've seen too. I'll just give an anecdote. I was talking to the Berlin DPA, and we were talking about methods you could do or apply to protect the data and so forth. And he said, why don't you just redact all the data, which was completely blind to the volumes of information you produce and huge litigations. But that was his simple solution.
Anonymize, redact.
Yeah, just redact it.
Yeah,
Surely
it's
there
all
could
you
be
have to do.
software that could do this, and you try to stifle a laugh. But I don't know if you've had the same experience.
I mean, I would say on the sort of the company client side, I think there's a growing awareness that some sort of investigation of data needs to be carried out, at least in order to be able to present a claim or a defense, just because there's less pre-organization of data and because of volumes of electronic data and storage. So I think certainly when I was working in Germany along the way, there was not necessarily an understanding or acceptance of the scope of discovery or disclosure, but there was to some extent an understanding of the need to carry out electronic investigations, sometimes indeed on site, etc. So in terms of regulators too, I think regulators maybe are understanding the volumes of data involved, but still not quite making that leap to the actual disclosure process or discovery process. And that is a tricky one, and I think you're talking about redaction as an example.
Yeah, I mean, sometimes their opinions just seem surreal. And the other example is with the Hague Convention for Production of Evidence Abroad, which is a very formal process, which U.S. courts don't always accept and generally dislike because it takes so long. But
It is said to take so long. I'm not sure that it takes as long in the UK as people think.
Right? Okay.
They copy-paste from the Aerospatiale judgment of 1985 or whatever. The Hague Convention always takes a long time. It's become a sort of given that nobody ever tests, I think, now.
Okay,
It's
well,
just
that's
an assumption.
But their knee-jerk reaction is why don't you use an international treaty to get this information, which
Yeah. Before we move away from litigation, just sticking within domestic litigation, my story earlier of the Treasury solicitor getting knuckles rapped for handing over personally identifiable information without thought. Have any of you come across that in a purely domestic context? Or is it simply that nobody's applying their minds to it?
I can certainly speak for having received disclosure from the other side, which had been beautifully redacted apart from one that had been missed, which completely changed the focus of the case. And we certainly asked far more searching questions.
So that was, their fault may have been a data protection fault, but the tactics were nothing to do with data protection.
They'd gone along the right sort of lines, but having missed an individual's name, which I suppose would count as PII for the benefits of this, it certainly gave us a significant advantage.
They could have relied on data protection law as a means of concealing that name and done so properly,
Yeah.
but for whatever reason they didn't.
They applied a piece of software that was supposed to automatically redact everything, and it missed.
Yeah, I've heard about software like that.
Yeah. Well, I've seen, I mean, it's funny, I've actually seen kind of a different example where people are leveraging, and this has been reported as well, their subject access rights to
Yes.
get information ahead of sort of litigation disclosure schedules. And I've seen a lot of that.
People using subject access requests as a means
As a lever to get-
jump-starting the
Right, to
litigation.
get information.
You're not supposed to do that.
That's true, but-
The ICO frowns upon it, but in practice, if you have the right to demand that information, what's to stop you? There's potentially more tactical benefit to be obtained by using data protection, as there is a risk in not using it, not thinking about it, not applying it. Is that one way of putting it? Think about it in every case,
Well-
I think is the answer.
Yeah, I mean, definitely. That was the example I was giving where some litigants actually prefer not to disclose, and so
Yeah.
they can rely on data protection issues as a sort of a shield to produce or against producing. So, yeah.
There's an angle that many people, I think, won't necessarily have thought about. A slightly different tack. The FCA have written, in the middle of all this, they're running around trying to solve these litigation and IP dispute problems. And a letter comes from the FCA saying they're not entirely happy that accurate information was given at the time of the public offer, the initial public offering. What should the company be doing about that? Is there a data protection strand in this, Sue?
With respect to the specifics of the data protection strand, I probably will defer to Dan on that point, but I think certainly the obligations are different than in disclosure because it's a regulatory request and the regulator is going to have more and different powers and also is going to be probably much less convinced of any arguments against turning things over quickly and thoroughly in response to that request, especially since it's potentially a matter of public interest and everything else.
So it poses more of a threat, or there's less possibility of less reasons for beating a regulator off in this context?
I think so, especially since I think there's not the same proportionality argument in terms of what should be disclosed to the regulator. And so I think it's very much an issue where the company needs to be reactive and look cooperative and all of these other things very quickly. And the FCA probably has much more power quickly to seize information that it wants should the need or interest arise. So I think the company is in a different position there. I mean, obviously, the regulator receiving the information, obviously, that's different than turning it over to another party or its lawyers as well. So that from that perspective, it is a bit different from a data protection perspective. But nevertheless, the company should want to be obviously compliant still, but also thinking from a public relations perspective and everything else about having ideally put processes in place so that the company can respond to the regulatory request fully and thoroughly and quickly without even putting that personal data in play if that information is not relevant. I mean, for instance, here, the particular subscribers' preferences and profile pictures and whatever else presumably have nothing to do with the IPO and ideally will be somewhere completely different, not come into play if you turn over all of your correspondence about corporate dealings.
But if it's going to take you 3 months to separate them because everything's a mess, then it doesn't look particularly good vis-a-vis the regulator.
Exactly.
Dan?
It's information governance.
It's what we're back to.
It's all about that. You would hope that the financial and legal advisors involved in the IPO would have had this conversation early on, but
So part of the advice on an IPO ought to include getting your data in order to comply with the new world you've just stepped into, the new regulatory world you've just stepped into.
No, I agree absolutely with what you both were saying. When I see situations where it's a domestic demand, tends to be a lot fewer issues because you're permitted to disclose information, upon a properly framed request. But you still want to obviously disclose only the relevant information, and it's proportionate and so on. And that would be consistent with what you're saying. You just don't dump a whole dumpster load of information and hope for the best. So. And you would hope the ICO would be supportive of that approach, and the UK regulator would understand it too.
That's the ICO at one end of the street, but we're talking about the FCA down the other end.
And you would hope they would understand that too. I mean, the FCA, they're also in the UK and have read the papers. So, but yeah, I tend to worry a lot less with those kind of situations.
And whatever the extent you worry now, there's going to be more to worry about after May 2018. Or is it just an expansion of the same kind of problem?
I think it's an expansion of the same kind of problem. If you were to get it wrong today, you may get a slap on the wrist. If you get it wrong in 2018, you may get your hand lopped off. So the consequences of getting it wrong are more severe.
One last issue that's facing this poor company at the moment is a data breach. We haven't got much time to talk about it, but the word is going around. People are suggesting that some of this private information, which, let us remember, includes religious and sexual preferences as well as more humdrum information that's out there. And bearing in mind also we are in June 2018 at this moment. Sue, what's the problem?
Well, there are a few different problems here, but
as briefly as possible, what's the problem?
Fundamentally, the company should never have got into this position, regardless of the regulatory regime in place. But obviously, as Dan is saying, the consequences are significantly more onerous under the GDPR regime. As a practical matter, of course, the company also has a lot of PR concerns and everything else if there's a question of trust of the company. And there could be real life consequences for the users, especially with this sensitive personal information. It's not just sensitive because people don't want that information to go out, but it could have real financial consequences for them, which then, again, could subject the company to civil liability as well as regulatory fines and everything else. So there are a lot of practical reasons why it's a very bad idea to get into a position where there could be a breach.
Okay, so that's a technical issue. They've failed in some respect. What's the worst that can happen to them? What should they do on notification of or discovery of this breach?
Well, as you say, notification is really a very key thing. I think they need to address the situation very quickly and make the notifications very quickly, both because they're required to, and again, because the longer this drags out, the more it looks like the company has not been taking an appropriate response to the breach, to the issue. So I think, again, there are sort of parallel regulatory obligations and practical needs to be proactive, both because the company has to and because if it doesn't, it could be in all sorts of other pain because of that.
To be clear, there's two tiers of notification here. This is after the GDPR takes effect. Within 72 hours, you must, or a reasonable time, you get a bit of latitude. You must notify the regulator. It's only in some rather more extreme circumstances that you must notify the people affected if some serious consequence is going to follow from them. But it seems quite likely that if you're keeping a database of that includes religious preferences and dating preferences, that you're likely to trip into that area of further notification. Will, are you finding people bothered about security? There's an easy one for you.
Yes.
Yeah. Is that in fact going to be the main driver out of the GDPR, or is it that it's a problem for anybody, GDPR or not?
It's a problem, GDPR or not. Thanks to a lot of very high-profile cases over the last few years, actually not people leaving laptops on buses, but people having their accounts hacked, other dating apps that have had their systems hacked, which have had very, very public global repercussions. People are aware that cybersecurity having an active, proactive look at how they store data and what threats it's exposed to. That is next to GDPR assessment readiness is hardening. How do we make sure that we are as best protected as possible from outside threats? obviously it's very difficult to mitigate somebody inside who does something stupid. But if you've got good policies, procedures, and you train them, etc., it goes to offset that. But yes, the GDPR has become a bit of a focus for. We are far more exposed. Our clients are far more exposed if they get it wrong. So what can they be doing beforehand to get it right? And understanding your data and how it's accessed, what the sort of threat vectors to it are, is something we're certainly seeing an awful lot more consulting work around.
And that 72 hours is a pretty compelling motive for getting sorted out.
There are some very put upon IT security, heads of IT security, information security officers who are feeling a little bit that they need to have a good cast iron response plan, sometimes actually practiced in advance so that they know how it's going to happen, because there are plenty of organisations who know they're going to be attacked, and sooner or later somebody's going to get through.
Dan, is this an issue that's crossing your desk?
Yeah, we're seeing a lot more attention on cybersecurity, that's for sure. It'll get worse under the GDPR because then you'll have to report, whereas today a lot of companies have that sort of Hobson's choice. Do I report something that I technically don't need to report? Definitely get attention, or stay stum and hope for the best. And if it comes across the ICO's desk, then we definitely are going to be behind the eight ball. But yeah, absolutely, we're seeing a lot more focus on
I
security.
think it's the biggest single driver in the GDPR, isn't it? For companies
Yeah.
in certain areas, anyway.
For sure, yeah.
The fact that they must, within a very tight timetable, report that they've been hacked.
Yeah, that's. I think
Whereupon
that's
the
right.
whole information governance bit, do you know what it is you've lost? If you don't know what you had, how do you know what you've lost? We're pretty well at an end. None of you have asked any questions. Nigel is guaranteed always to ask a question. Let's have your question, Nigel.
Recent spat about the Privacy Shield.
Sorry, can you speak into that?
Can you hear me? Marvellous.
You're supposed to throw it, Amit.
No, I wouldn't have been able to catch it. Recent spat about the Privacy Shield, whereby the European Commissioner's office suggested to the US authorities that one of the President's orders negated the Privacy Shield. Someone responded, I think last night, saying they didn't think it did. But it's not necessarily a safe bet for the future. How do you think that's going to pan out?
That's definitely right. I don't think the presidential order, when you look at what it impacted, actually resulted in any weakening of the privacy shield. And that was how the U.S. laws interrelate. But the optics of it are terrible, obviously. And it's just these concerns are already latent in Europe. How it will pan out? Wow, I mean, that's a great question. I wish I knew. Who knows where that focus of presidential attention is directed?
Even as we're sitting here.
It could, yeah, we could leave the room and everything could be changed. So I wish I could give you a better answer than that. I know at the moment the shield is still structurally sound. A lot of quaking in Europe about what's going to happen. We just don't know, and you'd hope sensible minds would prevail as to making sure, because U.S. industry wants the shield. They would be very disappointed if that were to go away, just like the safe harbor. So, but it's a very unpredictable situation we're in right now.
We have to make certain assumptions now that we used not to have to make. One is that we're all still going to be alive by May 2018, and the other is that the US will still be conducting trade with the rest of the world. Those are not the sort of assumptions one used to have to worry about. Any other question? Yes.
Oh, cheers. Who, in your opinion, holds the budget to do all this?
Good question. Who, in your experience, it's not just your opinion, perhaps.
I can say who holds it now and who should hold it. Who should hold it is the easy answer. It needs to sit with the CEO and work down from there.
Okay.
It's partly cultural, but partly if the top of an organisation don't recognise their obligations to fix it, they will never assign budget to the people who are actually clamouring for it, be it a cybersecurity team, response testing from the IT department, be it risk and compliance saying, we need more people to come in and do audits. They will never get the budgetary approval for it. There were some cases a little while back when new regulations came in force that said senior managers are now responsible, personally accountable for things that go wrong. Yes, CEO, if this goes wrong on your watch, you may go to prison. Suddenly started open purse strings. This is an extension of that, of making accountability sit with a named individual. And generally, the higher it goes, the more purse strings they have available to them.
Any dissent from that? Any alternatives or
Don't have anything
additions
to
to
add
that?
to that.
Good question, thank you. Anybody else? Trouble with this audience is it knows it all anyway. all we've done is affirmed their prejudices.
I'll ask a question. I don't think I'll need that. Do you think the ICO will want to take a scalp relatively early so it can set a bar,
I think so.
particularly with a large organisation?
It'll be a carefully chosen one, not necessarily a large one that will have ripples. Beyond that, at least that's what I'd do if I was at the ICO. Our time is up. Thank you very much, all three of you, for giving your time to this, and particularly to Sue for the Thanks very much to ACEDS for organising it, and particularly the local ACEDS committee, and thank you very much for coming.